Hello everyone, and welcome to the second of our major liability and negligence videos, which covers breach of duty. And in this video we're going to look at the second part of our tortious liability equation. And the easiest way for me to place that in context is just to go back to that equation. If you remember, the first of our videos looked at what are the circumstances in which the claimant can be owed a duty of care by the defendant. In this video we're going to cover what are the circumstances in which that duty can be broken or breached. Now I'm going to give you a case law warning. This is a case law heavy video. There are lots and lots of bits of case law for you to remember. I will try and explain them one by one. I'll try and place them in context, but there's no other way for you to get this under your belt than just to learn and remember the case law. So, where are we going to start? We're going to start with the reasonable person. Once the claimant has established that a duty of care exists, he must show that the defendant has breached that duty. And the standard of care to which somebody has to carry out that duty is the standard of the reasonable person. What that is essentially saying is that if I have a duty, I am expected in the eyes of the law to carry out that duty in exactly the same way that every other member of society would carry it out. Now that's what we mean when we refer to an objective test. Is that what would everybody else do in that situation? If everybody else would do the same thing that I have done, then I've behaved in accordance with the reasonable person and I have completed my standard of care. If the way in which I carry out that task is less than the way everybody else would carry it out, I have fallen below the standard of care of the reasonable person. And if you recall, the definition was given to us by Baron Alderson in the Blythe versus Birmingham Waterworks case of 1856. And in that, Baron Alderson says, negligence is the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. And we also said, the easy way of saying that is by saying it's about doing something that you shouldn't or not doing something that you should. But what Alderson has done is he's made it very clear that that doing or not doing must be to the same level that the reasonable man would do. What that gives us in terms of our standard of duty and breach is a continuation of this diagram. And if you recall this diagram from the last video, we said those first three elements constituted what is required to demonstrate a duty of care. And we demonstrate a duty of care by looking at the Caparo test. And in the Caparo test, from the case Caparo versus Dickman 1990, we looked at whether or not there was reasonable foresight of harm. We looked whether there was sufficient proximity, and we looked at whether or not it was fair, just and reasonable to impose a duty. If we have each of those three things, then we can say we have a duty of care exists. If we have a no to any of them, and there should be a no there, then we immediately have no liability in negligence. So this is a every hurdle must be jumped set of tests. If we can demonstrate that there is a duty of care, then we go on to ask, has the defendant fallen below the required standard of care? Once again, a no will give us no liability. A yes means that we have proved duty and breach. Now this required standard of care is the standard of care of a reasonable person. So, has the defendant fallen below the required standard of care, and that required standard of care is the same standard that a reasonable person would have carried it out. In deciding whether or not the reasonable person would have done the same thing that the defendant did, there are a number of factors that can raise or lower the standard. There are 5 actually. And this is quite logical because it's based on the risks that a reasonable person may take in certain circumstances. So, what that essentially means is that there are given situations in which I and everybody else in the United Kingdom might behave that would be different given a different situation. And if that is the case, then we have to say that that has had an impact on the way in which the reasonable person has behaved and given their standard of care. That'll become more apparent as we work through this. The 5 key factors are that are there any special characteristics that pertain to the defendant? Are there any special characteristics that pertain to the defendant? Look at that, I've got those the wrong way around and I've missed an I out there. So are there special characteristics of the defendant? Are there special characteristics of the claimant? What is the size of the risk that I am taking? Have all practical precautions been taken? And what are the benefits of taking the risk that I've taken? And I'm going to look at each one of these in turn as we work through the video. For you, when it comes to your exam, any answer on breach should start by explaining that the standard of care is that of the reasonable man. Then you can go on to describe and explain the factors, these 5 factors, by reference to decided cases. And you can dismiss those, you don't even have to write about those, that are not relevant. What I will do is I'll do a video that looks and talks us through how to write an answer a bit later on, a bit closer to the exam. So, let's start with looking at whether or not there are any special characteristics of the defendant that might raise or lower the way in which the reasonable man would perform that duty. And the first thing to say is that the standard by which the defendant is judged is the standard of the reasonable man performing the task, not by his own standard. So, for instance, if I am driving, and we'll come to driving in a moment, if I am driving on the road, the standard by which I am judged is how would the reasonable man drive, not how I would drive. If the reasonable man would drive the same way as me, then I have met the standard. If the reasonable man would drive better than I did, then I have fallen below the standard and I have breached my duty. So, as another example, which we're going to start with our case law, a householder carrying out DIY, do it yourself, must not fall below the standard of a reasonably competent carpenter in this instance. And the case we're going to look at is Wells versus Cooper. In Wells versus Cooper, the defendant fitted a door handle to his home. The claimant was a visitor to the defendant's home, and he pulled on the handle and it came away in his hand. That caused the visitor, the claimant, to fall down several steps. The defendant was judged against the standards of a reasonably competent carpenter. But he wasn't judged necessarily against the standards that would be expected of a professional carpenter working for reward. He was judged against a reasonably competent carpenter. And that's because this was the sort of job that a reasonable householder might do for himself. And therefore, that was the appropriate standard to which he was judged. The standard of care required is the reasonably competent person doing the job in question. Now, if we think about that and we extend that a little bit further, in this case, by the way, the claimant lost. If we consider that and we consider what the judges said, because this was the sort of job that a reasonable householder might do for himself, then he is judged to the standard of the reasonably competent carpenter. If the householder was fitting a gas boiler that runs a central heating system, then it's likely that that's not the sort of job that a reasonable householder might do for himself. It's the sort of job that you would have a professional plumber do. So the householder that fitted a boiler would be judged against the standards of a professional plumber. Let's take a further look at that and look at the very, very famous case of Nettleship versus Weston. In Nettleship versus Weston, the defendant was the learner driver. Okay? And the claimant was the professional driving instructor, believe it or not. On their third lesson, and it's in a car that doesn't have dual control, so they weren't able to, the driving instructor wasn't able to brake for the learner driver. But on their third lesson, the driver crashed into a lamppost and injured the instructor. In this case, the claimant won. And the claimant won because the driver was liable despite her inexperience. The standard of care required of all motorists is the same, that of the reasonably competent driver. And if you think about that, my students think that's hugely unfair. Partly because most of them are learner drivers. But if you think about it, the decision is perfectly logical. If you were to say that wasn't the case and you extended it to other professions, that would be like saying, I am not liable for your care if I'm a doctor because I'm new. If you go into hospital, you don't expect the doctor that sees you to have a lower standard of care just because they're a trainee doctor or that they're a new doctor. You expect for them to look after you in exactly the same way that any other doctor would. And that's precisely the same as what goes on the road. When I go onto the road in my car, I expect that everybody else that's driving is going to drive to the competency of a reasonably competent driver. So in Wells versus Cooper, the claimant loses. And in in Nettleship versus Weston, the claimant wins. Now, I want you to consider a special set of circumstances, and I'm going to fly over these two cases because we're going to look at them in much greater depth when we look at the A2 level. But the question is to be asked, but what if the defendant is a specialist in their field? So what if their standard is higher than the reasonably competent person? And there are two cases that say slightly different things that are related. The first case is the case of Boleyn versus Free and Hospital Management Committee in 1957. And in that case, the claimant undergoes a course of electroconvulsive therapy as a treatment for depression, something that was common in 1957. And this involves the application of electrical current to the patient's head with the aim of causing seizures. In that instance, the doctor failed to provide the claimant with any muscle relaxants or any physical restraint. The claimant suffers severe dislocation of both hip joints with fractures to the pelvis on both sides. The court had to decide whether it was negligent not to provide relaxants or restraints. And in the court case, there were two bodies of opinion. One which favoured the use of relaxants, one which did not. And the principle that came from that case is that the standard of care for doctors is the standard of the ordinary skilled man exercising and professing to have that special skill. In this instance, there were conflicting views from practitioners on the use of the relaxants and the restrainants. As there were doctors, therefore, who would have acted in the same way, the doctor treating the claimant had acted in accordance with a competent body of medical opinion and therefore was not negligent. Claimant lost. So the standard of a professional is judged by the standard of the profession. So because a professional was able to demonstrate that other professionals would have done the same thing, he is deemed to have behaved in the standards of a reasonably competent person carrying out that same task. So the implications for that is that if you are an expert and you can bring to court other people, other experts, other people in the same profession who would have done the same thing, no matter how few of them there are, then you are likely to be shown to be behaving in the same way that a reasonably competent person would have behaved carrying out that same task. Now the danger with that, of course, is that if you have, let's say, I'm making these numbers up, but let's just say you have 10,000 surgeons in the country and you are sued, yet you can find 5 surgeons that would supported you, the body of evidence is still against what you would have done. But according to Boleyn, because you have found 5 professionals that would have backed you up, that means that you are behaving like a reasonably competent professional. Now, that seems a little bit odd. And so we then get to Boleyn versus City and Hackney Health Authority in 1998, some 40 years later. And in that case, the claimant suffered brain damage as a result of a doctor's failure to attend to clear a child's blocked airways by intubation. There was a difference of medical opinion again as to whether the intubation was necessary in the particular circumstances. So we have a similar situation. We have a divided opinion. Some say yes and some say no. And the court said that although there was a recognised body of medical opinion in accordance with the doctor's practice, the House of Lords held that a doctor could be liable in negligence despite the presence of a body of medical opinion in favour of his or her actions. The court decided that a body of opinion is not reasonable or responsible if it can be demonstrated that the professional opinion is not capable of withstanding logical analysis. So what does all that mean? It means that the Boleyn case states that when judging the standard of care required by professionals, the court can decide that the normal standard of acceptable conduct set by the profession is not high enough, and D has therefore broken their duty of care. So, in short, if you as a professional can show that there are other professionals that would do the same as you've done, generally you will win. You will be shown to be performing to the reasonably competent standard. But if the court thinks that actually that it bears no logical resemblance, that it can't be right that you've behaved in that way, the court can overrule it. So the Boleyn ruling allows a small body of professionals to back you up. The Boleyn ruling says that if the court disagrees with that, it can override it. Now, the Boleyn-Boleyn decisions are complex, and we will come back to revisit those in the Unit 2 videos, in the A2 videos. And finally, when we look at the special characteristics of the defendant, is this notion about what the defendant won't know won't hurt him. If the defendant does not know that the standard procedure is dangerous, they will not break the duty. And we use the case Rowe versus Minister of Health, which is a 1954 case for that. And in that case, a spinal anaesthetic, I think it's called an epidural, a spinal anaesthetic had become contaminated through invisible cracks in the glass vial. And when it was used, that anaesthetic paralysed 2 patients. The court said that the cracks were not foreseeable given the scientific knowledge of the time. The foreseeability of harm is clearly a major factor in determining how a reasonable person would act. And although actual foresight by D is generally irrelevant, a reasonable person would not have taken precautions against a risk of which reasonable people in that profession were not aware. So you have to be aware of the risk before you can be held liable for it. Okay, so those are the simple-ish factors that affect the characteristics of the defendant. So let's look at the second of our set of factors. What are the special characteristics of the claimant? And the key ruling for this is that a reasonable man will take more care when the situation demands it. And this factor relates to risks known to the defendant as a result of the peculiarities of the claimant. So, if I'm a defendant and I know that there is something wrong with the claimant, then I have to take greater precautions when dealing with that person. My duty of care is higher. And this is normally going to manifest itself when we look at employment. If I am an employer of somebody that I know has special circumstances and needs, then my duty of care must be higher for that person than it would be for everybody else. Two key cases here. Well, one key case and one that is a nice to have in your back pocket. The first and most famous is Paris versus Stepney Borough Council. And in that case, the claimant is a mechanic. His employers know that he's blind in one eye. All right, so there's colour in his eye there. He's blind in one eye. And whilst the claimant was using a hammer to remove a bolt on a vehicle, a chip of metal flew off and entered his good eye. It injured his good eye and he became totally blind. The defendants did not provide goggles for him to wear, and there was evidence that it was not the ordinary practice for employers to supply goggles to men employed in garages on the maintenance and repair of vehicles. So at the time, so you've got to forget health and safety law, which has come in since, but at the time in 1951, the standard of care was that goggles were not provided. So the defendant said, we have not breached our standards of care because we have done what everybody else would do. We don't provide goggles. The industry does not provide goggles. The court said the defendants owed a higher standard of care to the claimant because they knew that an injury to his good eye would cause him much more serious consequences than the same injury to a worker with two good eyes. If a worker with two good eyes had lost the sight in one eye, they'd still have the sight in a second eye. Where a defendant knows of an increased risk, more care must be taken. So increased risk equals more care. Your standard of care increases. So in this case, the claimant won. If Mr. Paris had been fully sighted, it was likely that the defendant might not have broken their duty of care. But as Mr. Paris was sighted in one eye, their standard of care increased. And this is also true of illness. In Walker versus Northumberland County Council, the defendant failed to alter an employee's workload after he returned to work following a nervous breakdown. So Mr. Walker effectively left work, went sick, having had a nervous breakdown at work caused by stress. When he returned, work knew that he suffered from stress and did nothing to try to help him by lowering his workload. And he suffered a second nervous breakdown. Again, Mr. Walker won. Northumberland County Council knew that he was vulnerable, yet did nothing about it. Their standard of care should have increased. Let's take a look at the third factor, and that is that one has to consider the size of the risk. And the key factor for this, the court will consider the likelihood of harm occurring. The greater the risk of harm, the greater the precautions that will need to be taken. And the way in which we demonstrate this is by looking at the two famous cricket cases, Boleyn v Stone and Miller versus Jackson. Both cases involve damage caused by cricket balls. And in both of those cases, the cricket balls have been hit out of the ground. In Boleyn v Stone, the ground had been occupied and used as a cricket ground for 90 years. So a long time. And there was evidence that on 6 occasions the ball had been hit out of the ground. So actually it's not over 90 years, it's been owned for 90 years, but the ball is hit out of the ground over 30 years. In Miller versus Jackson, cricket balls were hit out of the ground 8 or 9 times a year. So the risk in Miller versus Jackson is much, much higher. So in Boleyn versus Stone, 6 occasions over 30 years. Boleyn versus Stone, the defendant is not liable, the claimant loses. So the claimant loses in Boleyn v Stone. Sorry, I spelled that right. The claimant loses because the frequency of the risk, the likelihood of risk happening is low. Therefore, the precautions that are taken in Boleyn v Stone are perfectly adequate. However, in Miller versus Jackson, 8 or 9 times a year, as opposed to 6 times in 30 years, means that it's much more likely that the harm will happen. And in Miller versus Jackson, the claimant wins because the precautions are not sufficiently large enough. One other case to sort of consider when we look at that is the Haley versus London Electric Board case. And in Haley versus London Electric Board, the defendant, the electricity board, they had workmen that were preparing to carry out work on some underground cables. They dug a hole in the road, and in order to give the warning of a danger, they laid a long, so they didn't put these signs, but they laid a long-handled hammer, one of those big sledgehammers, across the pavement. The claimant, who was a blind man, tripped over the hammer and was injured. In this case, the claimant won because the defendant was liable, as although they had given adequate warning to sighted people, it was common knowledge that large numbers of blind people walked unaided along pavements, and the duty of care extended to them as well. So the size of the risk was greater. A reasonable risk to protect against is one that is statistically likely to occur. So if it is statistically likely to occur, then you need to protect against it. Okay? Now this is closely linked to the next thing, is understanding when you have a risk is that have all relevant precautions been taken? The defendant will have acted reasonably if he has taken all of the reasonable precautions. Think about Boleyn versus Stone and Haley that we've just discussed, Haley versus London Electricity Board. In Boleyn v Stone, there's a high fence, high-ish fence, and because it isn't likely to happen very often, the fence is high enough. There have been reasonable precautions taken. In Haley versus London Electricity Board, there's a high chance that it might happen and not enough precautions were taken. The reasonable man will do all he can to prevent injury to others. So he will do all he can. That's a key phrase. The reasonable man will do all he can to prevent injury to others. In unexpected circumstances, this may not prevent an accident, but the key is reasonableness. If the reasonable man does everything that they should do to prevent an accident, then they will escape liability. Even in circumstances that are unusual, where then there is where an accident occurs anyway, if the reasonable man has acted reasonably, then they will escape liability. And I can demonstrate that by using the case of Latimer versus AEC 1952. The defendant, AEC, are a factory owners, and the factory was flooded following a heavy storm. The claimant slipped on an oily film and injured his ankle. The sawdust put down to soak up the liquid did not cover the entire floor. The court said that the defendant had done all that a reasonable person would do in the circumstances. They could not have eliminated the risk completely, short of closing down the factory, and that wasn't practical. The court said that one factor in deciding whether the defendant has acted as a reasonable man is taking all practical precautions. So I'll just repeat that. One factor in deciding whether the defendant has acted as a reasonable man is have they taken all practical precautions. You are not supposed to behave in a way that is impractical, just in a way that makes common sense. Have you done everything that is common sense for you to do? And finally, the fifth factor is, what are the benefits of taking the risk? And this is about public utility. If we make people in public positions liable for trying to help others, they will stop trying to help others. So therefore, perhaps we should have a lower standard of care when reacting to an emergency. So this might lower the standard of care. The court must balance the risk against the measures and the benefit of public good. And there are a couple of key cases here for us. The first is Watt versus Hertfordshire County Council, quite a famous case. The defendant is a local authority that ran the fire brigade. The claimant is a firefighter who was injured by equipment that slipped on the back of a lorry. The lorry was used to carry heavy lifting equipment needed at a serious road accident where a person was trapped. The lorry, which usually carries the equipment, was engaged on another fire. It was out on doing something else. So the fire officer ordered the equipment to be loaded on the back of an ordinary lorry. As part of that process, because the right lorry wasn't used, the defendant hurt his back. Dennin, a very famous judge who we will visit over and over again, Lord Justice Dennin said that one must balance the risk against the end to be achieved. The saving of life or limb justified the taking of the considerable risk. And in cases of emergency, the standard of care demanded is adjusted accordingly. So the benefit of saving a woman's life outweighed the risk of injury to a firefighter when using the best but still unsuitable vehicle in an emergency. So because the emergency was more important, the standard of care was lowered. This also applies when making a rescue. And the final case we're going to look at is Day versus High Performance Sports. So Mrs. Day was a reasonably experienced climber, and she fell while climbing on an indoor climbing wall belonging to the defendant. Unfortunately, she suffered quite serious brain injury. At a height of about 30 feet, she discovered that she was not tied on to her top rope and had to be rescued by the duty manager because she froze in position. The court recognised that this was an emergency situation and the circumstances of the emergency had to be taken into account. In fact, the centre was one where a concern for safety was prominent and workshops on safety were given to all employees. The court decided that the climbing centre had not broken its duty of care. The standard of care can be lower when making a rescue. So in both of these cases, the claimants lost, because the standard of care is lowered where making emergency procedures. I know that doesn't make any grammatical sense, but you understand what I mean. Okay, so I'm going to go right back just to finish this video off to the part that I said over here. Okay, when it comes to answering exam questions, what I want you to do is I want you to think about, in the first instance, start by explaining that the standard of care is that of the reasonable man. Once you've explained that it's about the reasonable man, using Blythe versus Birmingham Waterworks, you then go on to explain the factors that might raise or lower the standard of care. What are the characteristics of the defendant? What are the characteristics of the claimant? What's the size of the risk? What precautions have been taken? And what are the benefits of taking the risk? Write about those that apply, dismiss those that are not relevant.